All right. If you're getting ready for the bar, some principles are so fundamental they're basically the operating system for everything you do in court. And today, we're diving into one of the absolute biggest, the federal court's core command to make sure that when a fight is over, it is truly, finally over. So let's start with a really simple question. What actually stops a legal battle from just going on forever? With people bringing claim after claim about the very same issue? Well, in the Federal Court of Australia, the answer is tucked away in one incredibly powerful section of its founding act. And there it is. This is the absolute heart of it. This is Parliament's direct instruction to the court. If you're studying, burn this phrase into your brain. It's not just stuffy legal language. It's a mission statement. The goal is complete and final determination. And the enemy, the thing to be avoided at all costs, is a multiplicity of proceedings. Okay, so to really get our heads around this for your exams, here's our game plan. We're going to break down the core command in Section 22. We'll get into the crucial difference between power and jurisdiction. Then we'll look at how the court actually ends relitigation using estoppel, see how Section 22 works in practice, and wrap up with finality and precedent. First up, the core command. I love this subtitle, Finish the Fight, because that is exactly what Section 22 is telling the court to do. This isn't some polite suggestion, it's an active duty, a command that applies to every single case that comes through the door. So here's the key takeaway. Section 22 commands the court to use all the tools in its toolbox, all the remedies it has, to achieve that finality. The courts interpret this section really broadly, or liberally, because they know its entire purpose is to stop parties from having to fight the same battle over and over again. It's all about efficiency, certainty, and ultimately justice. Now, this next point, this is pure exam gold, so really tune in for this. Section 22 gives the court power, but, and this is a big but, it does not give it jurisdiction. Getting this distinction right is absolutely vital. Let's make this crystal clear. Jurisdiction is the authority to even hear a case in the first place. It's the key to the courthouse door. Power, on the other hand, refers to all the tools the court can use after it's unlocked that door and stepped inside. Section 22 is the toolbox. It is not the key. It only gives the court power. And if you need the authority, which you do, here it is, from the huge high court case of Philip Morris. The court was really clear. It said it gets jurisdiction over a matter from other parts of the law. Then, Section 22 kicks in, imposing the duty and providing the power to finish that matter off completely. Nail that sequence, and you've nailed the concept. So if Section 22 is the command for finality, how does the court actually enforce it? What stops people from trying their luck again? Well, the answer is in the doctrines of estoppel. Think of these as the legal shields that the court uses to block parties from re-arguing their cases. First, you've got res judicata. It literally just means the thing has been decided. This is the most final, absolute form of estoppel. Once a court gives a final judgment on a cause of action, that cause of action is completely used up. It's exhausted. You simply cannot sue on that exact same claim again. It's a total shutdown. Next up is issue estoppel. This one's a bit more surgical. It stops the relitigation of a specific issue, a particular point of fact or law that was essential to a decision in an earlier case. So, even if you come back with a whole new cause of action, if a key ingredient of that new case is an issue the court has already decided, you can't argue it again. And finally, there's the really powerful one, Anshan estoppel. It comes from the old principle in Henderson v. Henderson. This is the one that stops you from raising a claim that you could have and should have raised in the first lawsuit. It's the classic you don't get a second bite of the cherry rule. If a claim was so tangled up with the first case that it was just unreasonable not to raise it back then, the court's going to say, sorry, you're too late. Okay, so let's pull this out of the legal theory and into the real world. How does this command to finish the fight actually change how things are run day to day in the federal court? Well, Section 22 is the ghost in the machine for so much of the court's procedure. It's the reason, under the federal court rules, a judge can consolidate different cases together. That's Rule 30.11. It's why a court can still order costs even after the final judgment is in. It's why a judge can enforce a settlement without you needing to start a whole new lawsuit. And it's why judges are so hesitant to order separate trials. They hate the risk of overlapping issues and getting inconsistent results. It all comes back to that one single command: determine all matters completely and finally. So we've got the command and we've got the tools like estoppel, but how do we make sure this idea of finality is applied the same way by every judge in every court? We need consistency. And that, of course, is where the doctrine of precedent, or stare decisis, comes into play. Stare decisis, another bit of Latin, and it just means to stand by things decided. It's the powerful yet simple idea that like cases should be decided in a like way. This is what gives our legal system predictability and stability. It ensures the law develops consistently. And for your purposes, the rules in the federal court are super clear. A single judge is strictly bound by the decisions of a full court. There is zero wiggle room there. The full court, on the other hand, has a little bit of an escape hatch. While it should follow its own previous decisions, it can decide to go a different way if it is convinced that an earlier decision was plainly wrong. It's a clever mechanism that allows the court to correct errors while still keeping things stable overall. So, let's wrap this up. Section 22 is the federal court's powerful mandate to finish the fight. It's enforced by estoppel and applied consistently through precedent. But that leaves us with a really important question to chew on. This relentless drive for finality is all about efficiency. But when does it risk becoming an instrument of injustice itself? What about the person who had a good claim but didn't bring it for some reason? Is it always fair to say, sorry, your chance is gone? That's the tension that lies right at the heart of this rule.